Good afternoon, everyone, and welcome to the first in a two-part podcast series on the Nigerian Data Protection Regulations 2019, which is commonly referred to as the NDPR. This series is brought to you by the Data Protection Practice Group of UUBO and Belo-Osagie. My name is Jumoke Lambo. I am a partner in the firm and head of the data protection team. For those who may not know much about our firm, UUBO and Belo-Osagie was established in 1983 and is a full-service corporate and commercial law firm in Nigeria. We are privileged to work with diverse local and international clients to create and implement innovative and practical solutions that facilitate business in Nigeria and beyond. Due to our various affiliations, we are very well placed to work with a select network of leading African and international law firms. Our areas of expertise are diverse and include, amongst others, telecommunications, media and technology, data protection, banking and finance, compliance and investigations, capital markets, and corporate advisory. I will be joined today by my colleagues Babatunde Olayinka, a senior associate in the firm, and Ifunanya Nwafor, an associate in the firm. In this first podcast, we will discuss the impact of the NDPR Implementation Framework 2020 on the existing provisions of the NDPR. As we have seen over the last 2 decades, and at an increasingly rapid rate recently due to the COVID-19 pandemic, digital transactions and online social interactions, and the collection, use, and unauthorized sharing of the personal information of customers and online platform users with third parties has grown exponentially. This has led many countries around the world to look at this development critically, and many have enacted laws to protect the privacy and the personal data of their citizens and residents. Nigeria is no exception. Due to the absence of a general data protection legislation in Nigeria, the National Information Technology Development Agency, commonly referred to as the NITDA, which is a regulatory authority, for those who don't know, with the responsibility for coordinating and developing Nigeria's information technology infrastructure. To avoid any lacuna, issued the Nigeria Data Protection Regulations on 25th January 2019 to provide the legal framework for data protection in Nigeria. The NDPR was issued less than a year after the European Union issued the General Data Protection Regulations, which came into effect in May 2018. Being the first regulation of general application on data protection in Nigeria, and because of the speed at which it was issued, the NDPR did not contain exhaustive provisions on data protection, and in some areas it was actually practically silent. These loopholes needed to be clarified by the NITDA for the benefit of organizations that process the personal data of Nigerian citizens and residents, and for other stakeholders who operate in the data protection and information technology space. To address some of these gaps, the NITDA actually proactively issued the NDPR implementation framework that I will refer to as the implementation framework going forward on 17th November 2020. And the essence of this was to provide clarity on the provisions of the NDPR and to enable data controllers and data administrators and processors to better understand and be able to fully comply with their obligations under the NDPR. It is important to note, as we start this conversation, that the implementation framework is required to be read in conjunction with the NDPR and does not supersede the NDPR. In this first podcast, we will provide insights into some of the provisions of the NDPR and how the implementation framework has provided further guidance to enhance compliance with the NDPR. Welcome, Babatunde and Ifunanya. Let's get this conversation started. Babatunde, I'll start with you. What would you say is the scope of application of the NDPR, and how does the implementation framework amend it, if at all?
Thank you very much, Mrs. Lambo. And I would also like to join you to welcome our audience to this podcast, which we hope you will find useful in better understanding the Nigerian data protection landscape. In response to your question, the NDPR applies to all activities pertaining to the processing of the personal data of Nigerian citizens and Nigerian residents. Prior to the introduction of the implementation framework, the scope of the NDPR was quite wide. This is because the NDPR applied to all transactions intended for the processing of the personal data and the actual processing of the personal data of natural persons in Nigeria, notwithstanding the means by which the data processing is conducted. The NDPR also applied to all natural persons residing in Nigeria or natural persons residing outside Nigeria but who are citizens of Nigeria. The processing of the personal data of such persons were required to be carried out in compliance with the NDPR. The introduction of the implementation framework provided further clarity on the scope of the NDPR because it limited the scope of the NDPR by excluding certain types of data processing activities. These exceptions include A. Instances where personal data is used in the furtherance of national security, public health, safety, and other by agencies of the federal, state, or local governments, or those appointed to carry out such duties on their behalf. B. Instances where personal data is used for the investigation of crime and tax offenses. C. The collection and processing of anonymized data. And lastly, D. The use of personal data for personal and household activities with no connection to a professional or commercial activity. The implication of the foregoing is that it is now clear that the NDPR is not intended to apply to any processing of personal data done under any of the above listed circumstances which have been exempted from its application by the implementation framework.
Many thanks, Babatunde. The issue of the scope of application of the NDPR has generated some concerns from data controllers and processors. And while your response shows that the NIDA is responsive, we know that there's still some questions around the extraterritorial reach of the NDPR, which was not limited or further clarified in the implementation framework. We suspect, as we practice, that the NIDA may provide further direction on this particular issue, and we will address this in subsequent podcasts or updates. So we just say to our audience, keep your questions, and at the right time, we believe we will provide you the answers. And I think this is a nice way to segue into to introduce Ifunanya. Ifunanya, another area that has generated some conversation has been the legal basis for the processing of personal data. Can you explain to our audience what the legal basis for processing personal data are in the NDPR? And also, actually, can you consider whether the implementation framework provides any additional guidance on processing and further processing of personal data?
Thank you very much, Mrs. Lambo, and it's really nice to be here. The NDPR sets out the 5 lawful grounds for the collection and processing of personal data. These are: 1. Where the processing has been consented to by the data subject. 2. Where the processing is for the performance of a contract. 3. Where the processing is required for compliance with a legal obligation. 4. Where the processing is required for protection of the vital interests of a data subject or another natural person. Or lastly, where the processing is necessary for the performance of a task carried out in the public interest. In relation to the further processing of personal data, the NDPR provides that this may only be done for archiving, scientific research, historical research, or statistical purposes in the public interest, and that any person or entity carrying out or purporting to carry out further data processing must not transfer the personal data to any person. Implementation framework provides clarity on the conditions which a data controller is required to satisfy if it intends to further process personal data which it had initially collected for a specified purpose. The implementation framework provides that in these circumstances, the data controller is required to consider and inform the data subject about the following details. 1. Whether there is a connection between the original purpose and the purpose or additional purpose. 2. The context in which the data was originally collected. 3. The nature of the personal data required for further processing. 4. The possible impact of the new processing on the data subject. And 5. The existence of requisite safeguards for the personal data. Based on the foregoing, it is now clear that a data controller is only permitted to further process personal data where the conditions listed in 1 to 5 above have been complied with and subject to the following. 1. If the data subject consents to such processing based on the new information provided. 2. The processing is solely for scientific, historical research, or statistical purposes in the public interest. Or 3. Such further processing is required for the data controller's compliance with a legal obligation. Where the further processing does not meet the above stated requirements, the data controller is not permitted to carry out any further processing of personal data.
Thanks, Ifunanya. That was a very helpful clarification. And this leads me actually to another topical issue, consent. What is consent under the NDPR? And does the implementation framework provide any clarification on this issue? I would like to direct this question to you, Babatunde.
Thank you, Mrs. Lambo. The consent of the data subject is one of the lawful grounds for the collection and processing of personal data under the NDPR. It is very important for every data controller or processor to comprehend what consent entails so as not to infringe the privacy rights of data subjects. The implementation framework has clarified that the consent of a data subject means any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, through a statement or a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. The implementation framework provides further clarity on the concept of consent in the NDPR. It recognizes two types of consent. These are explicit consent and opt-in consent. Explicit consent is given where the data subject provides a clear and documented consent by ticking a box, signing a form, or sending an email signifying his consent to the processing of his or her personal data. An opt-in consent, on the other hand, occurs where the data subject chooses to give his or her consent by opting in and agreeing to the processing of his or her personal data for a specified purpose, which is disclosed by the data controller or processor. The implementation framework also makes it clear that the implied consent of a data subject is not recognized under the NDPR, and as such is unlawful. The implementation framework provides further clarity on the nature of consent that is required to process sensitive personal data. For purposes of the NDPR, sensitive personal data include health information, criminal records, information that are classified as of a sensitive nature. The implementation framework clarifies the provisions of the NDPR by providing that the explicit consent of a data subject is required for the processing of sensitive personal data. As I said earlier, this means that the data subject must provide a clear and documented consent by ticking a box, signing a form, or sending an email signifying his consent to the processing of his or her personal data. The implementation framework also addresses the principle that governs consent, and it provides that certain principles are to govern the giving and obtaining of the consent of the data subject. These principles are: 1. Transparency. There must be a privacy policy providing the data subject with vital information about the processing of his personal data, such as the type of data collected, how it is processed, whether or not the data will be transferred to third parties, and the security measures that is in place to protect the data. 2. No implied consent. Under the Ndpr, consent cannot be implied. Consequently, this implies that silence on the part of the data subject, or whether the data controller provides pre-tick boxes to the data subject, does not constitute consent. And lastly, consent must not be bundled. This means that the general terms and conditions of a service which is indicated in a document must be separated from the consent request to the data subject. Also, the data controller must provide separate consent requests for different types of use of personal data where such purposes or proposed use are unconnected. Additionally, the implementation framework provides further direction in relation to the issue of the age of consent, third-party data processing, and use of cookies by data controllers, as we will discuss subsequently.
Thanks a lot for that information, Babatunde, which I hope our audience found to be helpful in addressing some of their questions. Still staying with you, though, Babatunde, I'm not going to let you go just yet. On the issue of consent, the Ndpr was silent on who a child is. Would you say the implementation framework has provided any further clarity on this issue? And also, can you address the issue of cookies and whether consent is required for their use in Nigeria?
Who is a child for the purposes of the Ndpr? In relation to the age of consent, the implementation framework clarifies that a child is any person below the age of 13 years. The implication of this provision is that any person below the age of 13 years is not capable of giving consent. It further requires that data controllers or processors who intend to process the personal data of children must ensure that their privacy policies are prepared in a child-friendly format, such that a child or his or a parent or guardian can clearly understand before granting or refusing to give their consent. Is consent required to use cookies in Nigeria? With respect to the use of cookies, the implementation framework provides that the use of cookies on a website or other digital platforms requires the consent of the user. It goes further to state that consent must be freely given, informed and specific. Consent for the use of cookies does not require the ticking of a box or similar methods. Instead, the continued surfing of a website upon receiving a clear notice of the use of cookies on such website indicates consent of the data subject to the use of such cookies. The implementation framework has, therefore, provided that the continued use of a site which has not met the following requirements constitutes the consent of a user or data subject. Number 1, the provision of clear and easy to understand information of the use of and purpose of the cookie by the data controller or processor. Number 2, confirmation of the entity responsible for the use of the cookies. And 3, The data controller or processor must provide easily accessible information on the process of withdrawing consent, and the process should be made easily accessible to the users.
Thank you, Babatunde. As we can all hear, the implementation framework has actually gone a long way to address a number of the concerns around the NDPR provisions on consent. And this should make the NDPR's application easier in this respect for data controllers and processors. At least we hope with this podcast as well, you would have been able to be further enlightened about the implementation framework. If anyone still has any questions, I will share how you can reach us at the end of the podcast. So please direct those questions to us, and we will be glad to be of assistance to you in providing responses. Our last question today will be addressed to you, Ifunanya, and it is on the topic of a breach of the provisions of the NDPR or a privacy breach generally, which is an area that we're seeing more and more data controllers and processors being concerned about. Ifunanya, what does the implementation framework say about what should happen in the event of a data breach?
Thank you, Mrs. Lambo. The implementation framework provides that data subjects, civil societies, government agencies, and professional bodies are encouraged to report breaches of the NDPR through various channels. This will encourage accountability, compliance, and foster the objectives of the NDPR. The implementation framework also requires data controllers to report personal data breaches to the NITDA within 72 hours of being aware of such breach. And this timeline is required to be included in the data controller's data protection policy and data privacy policy. The information to be contained in the notification to the NITDA includes the description of the personal information involved in the breach, a description of the circumstances of such breach, the period during which such breach occurred, amongst other information. The implementation framework provides that upon receipt of the data breach report, the NITDA may take any of the following actions. 1. Contact the organization to make enquiries. B. Review the earlier filed annual report, if any. 3. Issue a compliance query. 4. Commence other administrative actions. And lastly, report the defaulter for possible prosecution. In addition, where the personal data breach will likely result in high risk to the freedom and right of the data subjects, the data controller is mandated to immediately notify such data subject. Reporting requirements set out in the implementation framework is in line with best practices and would ensure that the risk which data subjects are exposed to in the event of a data breach is mitigated, as it requires all stakeholders to be notified within a reasonable period of the occurrence of the breach.
So, ladies and gentlemen, we've come to the end of our podcast. Thank you so much, Babatunde and Ifunanya, for this really interesting session on the impact of the implementation framework on the provisions of the NDPR and how it has gone a long way to clarify a number of issues that were unclear in the NDPR. I thank you all for listening, and we hope that you have found this podcast helpful. As I said earlier, if you have any questions or comments based on this conversation, or have any other questions around data protection, please reach out to us at dpteam@uubo.org. I'll say that again, dpteam, one word, @uubo.org, and we will be happy to respond to you. On a final note, we hope you're aware that all data controllers have an obligation to audit their data protection practices and processes annually, and to submit a report to the NITDA where they process the personal data of more than 2,000 data subjects in a 12-month period on or before 15th March each year. The audit and filing can only be handled by a NIDA licensed data protection compliance organization. Our firm is a NIDA licensed DPCO, and we would be happy to assist you to prepare your audit report and to file it with the NIDA if you fall within the threshold of organizations who have an obligation to file a report with the NIDA. Please reach out to us if you have any questions in this regard as soon as possible, as time is of the essence and the penalties for non-compliance are steep. Everybody, we'd like to thank you so much for joining us today. And from Babatunde,
goodbye everyone, and thank you for listening.
From Ifunanya,
thank you all for joining us this afternoon.
And from me, please look out for the next podcast, which will be in the next couple of weeks. Thank you, and God bless you all. Have a good day. Bye-bye.